There was a period of time, I think the assumption is if somebody pays you to do the work, that means they own the rights to the work.
So that was like in 2021 when the Copyright Act was amended. But that change only impacted photographs.
There are a lot of freelancers that don't get paid. I studied about up to 100 people, and in this survey, 25% of them had not got paid. The problem is sometimes freelancers don't have a contract or agreement in place.
The one thing that creators have to know about AI is that whatever you use AI to create, there's a possibility that it may not be protectable by copyright.
Welcome to TFC Business Show live at Whiskdom today. So thank you for the Whiskdom folks for lending us their space to do this very important IP creator event. I think the genesis for today's event is because one of our good friends, the post went viral. Okay, and we realized that there are a lot of creators out there that are struggling to understand where are the parameters, what is their rights, where to recourse, and how to protect themselves as they build their IP business. Right, so we are very excited to be here at a cafe live with 20 of people. You can't see them, but they're there to discuss this hot topic. Okay, so maybe for a start, before we go on around, just introduce yourself to our audience at home.
Hi, I'm Chanel. I'm the creator of Toastys. You might have seen some of our animated content on the internet. We have
The joke's getting very bad.
What? What do you mean?
The joke's getting very bad.
Yeah, we make memes out of daily life. So we have 5 different toasts with 5 different emotions, and our aim is to bring joy to everybody with our relatable content and merchandise.
Okay, fair. And we're joined with?
Hi, I'm Pin Ping. I'm an IP partner with the law firm Bird & Bird. I advise many creators and content owners, collecting societies on how to protect and enforce their IP rights. So happy to be here today.
Yeah, you will be taking a lot of questions later. Okay, so we'll get there, yes.
Hi everyone, my name is Laura. I am primarily an actor and MC. I've been working in this industry for 18 years. Today I'm here representing VICPA as a creative freelancer, someone who works in a business as well. But VICPA stands for Visual Audio Creative Content Professionals Association. But basically, we are under NTUC and we represent creative freelancers in terms of work issues. We help to kind of take care of all the more business and work matters.
Great. So later we can talk a little bit about, another route of recourse through the VICPA union. Okay, so maybe for a start, how about without giving in too much, share a little bit of what happened, like the juice, how we ended up here.
Right.
Yes.
Yeah, so last year I exhibited my brand at this event called Potholes Show, and I think it was one of the best events that I had done for my business up to that point. And then during the event, we had many inquiries of people who were like interested to stock our products in their stores or carry our brand. And of course, I responded to everybody with a lot of enthusiasm. We started some contracts going. Then one particular stockist, I think they started putting our products in their store end of September until January of 2026. I still had not seen a single dollar come in. So I started raising some alarm bells because I personally was away from Singapore in November for a month. And then, December, I know it's Christmas period, so everybody very busy. I was like, okay, let's wait a while, Then I started asking for payment in January, and then that's where I was like, oh, red flag. I sold up to that point. It was at least 4 figures, if I remember correctly, almost 5 figures worth of invoices that were due me. So I was like, oh, yeah, because I know some creators here, maybe you've been in the space longer than maybe me, I'm not sure, or maybe even I wasn't even a creator back then, but I remember the news, like Nice. It was a local multi-brand retailer that took in a lot of local products, and a lot of creators didn't get paid because they expanded too quickly. I remember that news and I was like, oh, no, I don't want this to happen to me. So yeah, so here we are.
Okay, fair. So that is the backdrop, but I think we'll expand it to discuss a little bit about how to protect yourself, but maybe that's slightly later. Maybe question to Ping first. So in such a scenario, right, where she has essentially put the product with stockies, and they retail, and then they're not paying her back. What are the ways to go about pursuing this?
Right. If you go to a lawyer with that question, the first question the lawyer will ask you is, of course, where's the contract? Do you have a written contract? And many times we are told, oh no, so is there a written contract?
Yes, I had a written consignment contract. Yeah.
So I think that's the first step to being able to claw your monies back, because then there's like more of a recourse. Whether you go to the small claims tribunal or if it's a larger sum, you might consider going to the courts. But a self-help mechanism would be to ask for monies in advance if that's even an option. But I know that might be practically not very practical.
It's not very
if you're
real,
trying
right?
to,
Like, I think for a lot of the smaller
You're
creators,
just happy that
especially,
somebody is coming to
somebody
you.
take my barang, go and sell, very happy, right?
I think consignment also usually is when they sell, then you get the funds.
Correct. Which I understand in the space in industry in Singapore, most businesses actually run on consignment. Very rarely are we able to sell wholesale within Singapore. It's just a local business culture here. It's not like that overseas. But unfortunately, as a small business, the culture is like I'm not like crazy popular yet, so I have to.
I mean, but you still deserve to get paid.
Exactly.
I think even you're not crazy popular, everyone deserves to get paid for things that they produce.
Consignment or wholesale, either way, we deserve to be paid, right? But I mean, wholesale, of course, you get your money up front, but consignment, you don't. So you actually bear all the risk because you are the one putting your product in the store. You've already paid for the cost of goods. You've paid to deliver there, and then you are potentially covering petty theft because they normally consignment contracts. There's a clause like they're not liable for things that go missing or get damaged. So you're already bearing all the risk. The person or the retailer, they're bearing the cost for the manpower and the retail space in Singapore, which is expensive. I get it. So we both take risk, right? By the end of the day, you collect the money on behalf of me. So there is money go in, then the money go where? Right?
Yeah, I mean, this is like when you even in F&B, right? You pay suppliers. You make your own, like right here in Whiskdom, you make your own coffee or your goods and all that, your bagels, but you still have to pay suppliers. It's the same thing. The red flag there is also that you bear all the risk, and that's very dangerous in this case, especially because you're a micro business owner. It's technically you're no longer like a individual, like just doing this for fun. You are a micro business owner. Bearing all the risk is always a dangerous, like, if something goes wrong,
of course.
the one that
There's always the
loses.
ideal, then there's the market, right? The market has certain practices and what it is. But Ping Ping, actually, can you elaborate a little bit more? Because everybody say you must have a contract in place. That's what the lawyers say. All lawyers tell me the same thing, right? But
I will also tell you the same thing.
Yeah, I mean, everyone tell me the same thing. Then it's all template. But anyway. But what needs to be in such a risk? So we square this, right? She already is merchandising the product. Now she's trying to work with the retailer to go out, right? So it's probably like a consignment contract or something like that, right? So what within this contract should exist, or what are some things you definitely need to look out for? Because I would fathom a guess that some of the smaller creators may be using the other party's contract, or you may not even have the ability to run your own contracts, right? So at least give us some high level pointers. You must see this, and what are common.
I guess like if you're talking about like in this case, the dispute is purely about like you owe me money, you didn't pay me money. In which case, then the terms that are in question is really how you, like the payment terms, like how much you're paying, when you're paying, and things like that. So there's no magic to it. But I guess like if since we're in a group like of creators, we're talking about a group of creators here. The normal kinds of things that you want to see in a contract that you put in place with any partners would be that you retain the ownership of the IP in any works that you create. So for example, in your drawings, just make sure that's clearly stated in the contract that who it belongs to. Sometimes when you create something on behalf of a customer, the customer might say, because I'm paying you to create this, I want the IP to belong to me. That's fine, right? Because it all goes into the payment terms anyway. Other things would be like if they ask you like, oh, for a warranty, sometimes you have seen like that they say, give me a warranty and indemnity that whatever you provide to me doesn't infringe on third party rights, because they're also concerned that maybe this drawing that you got, you took it from somebody else or you took it off the internet, then you give me this thing, then suddenly I get sued. Then what's going to happen?
Hey,
right?
don't creators, don't okay.
So that the warranty and indemnity to that effect, to say that you warrant that it doesn't infringe my third party IP, and if some third party comes after me, you have to indemnify me for my legal costs and any damages that I have to pay to the other side. Will be to protect them. And I would say it's quite normal to agree to these things. You might want to consider carving down by saying things like, to the best of my knowledge, it doesn't infringe. So at least then you tell them that, look, this covers like willful infringement. Like if I intentionally go and copy, then that's something. And I guess like one very topical thing to bring up now would be AI, right? So everybody is using AI to do bits and pieces of things, but just be aware that whatever you use AI to create, it might not be protected by copyright. Right, but I don't know if you want to get into this whole
Yes, we'll get there.
now.
We'll
Maybe
get
later.
there. Yes,
yeah.
slightly later we'll get there. But maybe one more question based on what you've said, right? So something a bit puzzling was this whole, if somebody pays you to do the work, that means they own the rights to the work. You know, like there was a little bit
not
of
automatically.
yeah, exactly.
Yeah.
So there was a period of time. I think the assumption is whoever pays will get the rights to whatever they are creating. I think I'm not sure if that's
the whole
still
thing about commission works, right?
yeah.
So that was like in 2021 when the Copyright
Yes.
Act was amended. But that change only impacted really photographs, because it used to be that initially if you take a photograph of somebody, then like wedding photos, right? There was this whole like hoo-ha. Then the IP rights under the old position, the default ownership belonged to the people who are being photographed. So it would be the wedding couple. But then after 2021, the statute was amended so that the rights, the default ownership is to the photographer. So if the client wanted the rights, they have to ensure that under the contract, it says that the rights go to them. So that was the whole hoo-ha. But for other kinds of works, the position didn't change. So basically just make sure that it's clearly stated in your contract who the IP belongs to.
Okay, fair. So we'll go into the sexy stuff in a while, right? So, but maybe VICPA can talk a little bit about the recourse, methodology, because I think in the case that she was in, trying to pursue the money, and then
There are a lot of freelancers, actually, creative freelancers, not only, of course, creators of merchandise, but other freelancers in, for instance, the fields that I work in photography, in videography, in production, everywhere, they don't get paid. Unfortunately, I myself did a study a couple of years ago, and in my study, I studied about up to 100 people. And in this survey, 25% of them had not got paid in the previous 2 years of the survey. So that's like 1 in 4 didn't get paid.
High.
So that's a very high percentage. When you work in a company, right, technically you won't face that. But the problem is sometimes maybe freelancers don't have a contract or agreement in place. Sometimes they don't have ways of chasing debt, or they feel just completely lost. They just don't know where to go to, who to ask for help. And so VICPA was set up in 2021 to help some of these freelancers because they're under NTUC, so they do have legal avenues you can go to for advice as well. For instance, if you want to file, if your claim is under $20,000, you can actually file with the Small Claims Tribunal. And some of us may not know, the whole process and all that. So if you are a VICPA member, you can actually file a work advisory with VICPA, and they can go through the contract, the agreement, the different steps. So you have to compile the documents and even accompany you to SCT to file as well. So these are things you can do, perhaps get back your money. But of course, IP is also a separate issue. So we do have MOUs with IPOS, the Intellectual Property Office of Singapore, as well as WIPO, which is the World Intellectual Property Organization. And all these actually give you access to IP clinics, IP mediation, and all that.
So I guess if you have not heard of the Small Claims Tribunal before, it's basically a self-represented tribunal, forum. So people don't go there with their lawyers; they go there and speak for themselves. Right, so that helps you with the smaller value claims, because you don't have to incur the cost of hiring a lawyer. If it's just a $20,000 claim, then and if you pay half of that to a lawyer, then it doesn't make sense.
Yeah, and also very important to have all your agreements in place. So not only lawyer will say that, every freelancer has to have that. No matter where you are a business. You have to take care of your own self. Unfortunately, in the climate in Singapore and in more smaller Asian countries, also you have to take care of yourself. So your agreement, it has technically verbal agreements work,
yes,
but safest to have it down in writing, in proper contract, in WhatsApp, in email, just write everything out.
The problem with verbal agreements is, again, proof, right?
Yes.
Burden of proof. Because when you go before a tribunal before a court, it will be he says, she says, and then who is the correct party? What was the other thing?
And there's a bit of a hassle in proving verbal records and all that. So
correct.
best everything right in text.
And then I think there was this mention of like signing on the other side's template terms. So it's not just have a contract in place. Please read your contract before you sign it. Especially if it's on the other side's template terms, you can be very sure that it's favorable to them, right? So they'll sign in lots of things where it's like, and if you push back, oftentimes they'll say, okay, it's a reasonable pushback, I'll accept it. But if you just blindly sign, then too bad. When it comes to like a dispute arises, then that's the first time you read your contract. That's ideally not what's supposed to happen.
I got a question. Because this morning I just signed another contract. Then I was like, I was sitting on it for a while because I scared already. Can I ask question now? But too bad I signed already, but I just asked, okay? Okay, for example,
call your email.
Yeah, no, very simple one. They it's a new retailer, and then they were like a very big one. So obviously I cannot fight their template, okay? There's no way I can fight their template. It's already on DocuSign. But basically they want me to hire a promoter for the 2 weeks that I'm there. I said don't want. I will lose money because Monday to Thursday, not enough people. I don't want to pay Monday to Thursday promoter. Then we compromise Friday to Sunday. Then I was like, can you edit and write this on the contract? She said don't need. Then I was like, never mind lah. We had this conversation on WhatsApp, so I just screenshot. Then I signed. Like that,
right. So I think the legal answer is that in some contracts, in many contracts, there will be this
on the
thing
internet,
called
so
an
IGG.
entire agreement clause, which essentially says that everything that we agree to in relation to this subject matter, so in that case, your whatever like a consignment, is fully captured in this contract. So everything by the black letter of this contract, nothing else is relevant as proof as to the intention of the parties. So if there's that clause, you've signed to it, your email will be irrelevant. So of course, if it goes to whatever, then you can try to adduce evidence of the email to say, oh, but this was not whatever lah. But yeah, but it will be a bit difficult if there's an entire agreement clause in the contract. But if she told you that no need to change, then there's a possibility that that particular term is not there because it's just nitty-gritties of like the commercial terms that sometimes people don't bother to write it in the contract, which is fine.
But it is written there from every day of the week, the promoter.
No, it just says number of promoters 1. But never say what they must.
Okay, that means it's kept
so
big.
it's big.
It's kept
Yeah,
big. Okay,
it's big.
that's fine. Yeah.
No,
So,
but I mean, I think they are collaborative lah. It's a big name. They're not gonna,
no, and
But
I think
I was just like, okay, never
that's
mind.
essentially a big part of how
But after this experience,
business
I got scared.
operates, right? Yeah. So like there are legal bounds, yes, but there are also like business practices that then come into play, right? So that is that. We'll move into that in a while. Maybe one last element on small claims tribunal, because I think when Chanel was looking at trying to go through a process of recourse to get the money back, I think she read the small claims tribunal site and all that, and then
I'll elaborate. So
yes.
on the website, there's like a
Anyway, this is not legal advice, huh?
yeah.
Right. I heard you say.
Okay, but basically when you go on the SCT website, then they have like a checklist for you to do a checklist before you file your documents, right? So on the checklist, it asks, do you have a consignment agreement? Then I say yes. Then he said, consignment agreements are not covered by SCT. Then I was like, what? I thought like, yeah, so then I was like, then I asked AI and then I looked around. So the next step was you need to file an affidavit to go and represent yourself if you don't want to hire a lawyer and bring it to a different court. I forgot the name of the court, a bigger one. Yeah, then I was like, oh man, so much
Magistrates,
effort.
maybe.
Sorry?
Magistrates.
Yes, correct, magistrates, yes. Yeah, so like, but then after the post went up, quite a lot of people left in the comments or DM'd me privately and said that actually you can ignore that and you can just go and file. So I don't know like what is true because I was just following the website. So I thought, I'm done. Like I cannot do it. Yeah.
You have
I'm not familiar with SCT because they don't use lawyers there.
It's true. If you go through the
don't
process,
realize
you will
that.
know.
Oh, that's true.
Okay,
Right.
If SCT can comment in the comment section, we welcome your clarity. Like that will help the whole creator lot. But
Yeah.
I think that was a great, opening discussion on like recourse and like what happened and what are some things that most people need to do, right? So if you have any further questions, put in the comments. We'll try to address it as we go along. Okay, and for live audience, hold your horses later. we'll get to you. So maybe we move the conversation down the idea of building a brand, building an IP. How do we go from there, right? So I think for a lot of people, especially when they're first starting out, it's really just I don't know if I can use the word like passion, like out of a creative outlet, try to design something. People just like creating, right? I think I genuinely think most creators they begin by wanting to create, not by wanting to set up a huge business. Okay, I can't speak for all, but most people, that's what they want to do. And eventually it becomes a business, right? Because they say, oh, yeah, can do this, can do that. And then you kind of move along, right? So in this natural process of then building the IP to get to where it is, what are some milestones or what are some things that you need to do, to essentially build and protect your rights at the same time?
So maybe we take your scenario, right? So for someone like Chanel, the two types of IP that she'll be most concerned with, the first one would be copyright. So whatever drawings that you do, copyright protection arises automatically. The moment your drawing is like put down on a piece of paper or done in the digital form and stored in the computer, there's automatic copyright protection. You don't have to register. So that's the first thing to remember. If somebody copies your stuff and uses it without your permission, then that's infringement. You can try going after him. There are certain factors to consider as to whether there would be infringement, or the other side can rely on defenses like fair use and so on and so forth. The other type of IP would be trademarks. So your brand, if you have a brand name for that certain thing, it's good to get a trademark registration for the brand name. So like Nike, right? That's Nike, which is the name. There's the swoosh logo. So these can be protected separately. And you'll see that some people have also protected what we call the composite marks. So maybe the swoosh together with the name. And the reason why you do so many different protections is that when somebody infringes, the comparison will be a mark for mark comparison, your mark against his mark. If somebody takes something that looks like a tick, but then without the words, right? Imagine I only have tick plus Nike. Then if somebody makes a tick and then he puts his own name on it, like Chanel, then once I do the mark for mark comparison, there'll be more things to pick out to say that it's different, right? So anyway, trademark registration makes it easier for you if somebody copies your logo and sells the similar kinds of products or services under the same or similar logo. Basically tries to pass off himself as you.
I think milestones wise, obviously, if I speak on the business, how do we start making a business? You start from passion. And honestly, passion is a good thing. But personally, I don't like the word passion because passion opens you up for exploitation. Because you're passionate about something doesn't mean that
for free.
I need to do it for free. You're passionate, right? Why don't you do it for free? That's when it starts getting into exploitation. People start undercharge, underpaying you. Start trying to say you like to do it, so you should just do it. But that start off on passion. I think the milestones that you mentioned earlier is when you decide to start perhaps signing deals, brand deals. When you start to maybe hire people to help you, be it help you design, help you to create things and all that. That's when you start moving into a micro business of sorts. You start having money coming in and going out. And I think it's also essential to think about, this is a more business side of things, how you want to register yourself as a business. And in Singapore, you have the sole proprietorship, you have the partnerships, you have the private companies, and they all have different liabilities. So if something happens to the business, are you personally liable or is the company liable? So the money is separate from you. So these are all things I think we have to consider when we start going into this seriously as a business versus this is just my hobby. Yeah. So
and just to chip in just for 1 minute, which will be the point about signing contracts. So I think it's a good idea to be acquainted with the basics of contract, what the various terms in the contract mean. Because the ins and outs of the different templates, they will contain roughly similar terms. So if you're familiar, you read one, when you read the variations, at least you can try to roughly understand what you're signing up to.
Yeah, very important to read whatever you're signing so you don't sign your life away.
Yeah. Okay, fair. Yeah. Any thoughts on business building as you were kind of building this IP?
Yeah, so it has been very expensive.
Since they already thought about those technical things, tell me the business.
It's very expensive to protect your brand. I've spent high 5-figure amounts protecting my trademarks at this point. Frankly speaking, still not enough, because when you file a trademark, so later when you guys all go home and maybe you don't have a trademark yet, you want to file, you'll realize that the filing in Singapore is okay. Like one trademark, maybe $500. I think, if I remember correctly. I don't know whether there's inflation on it because I filed mine a few years ago. Then what happens when there's e-commerce? What happens when you get opportunities overseas? And then you start thinking, oh, I don't have a trademark filed in this country. Suddenly, every single country is another charge. And then you can potentially use something called the Madrid Protocol to see which countries you want to file in. And then on top of that, maybe you're just doing artwork. So everything's only one category, then that's okay. But if you're like me, you're making merchandise in many different categories. Each different class of merchandise is one class. So like, for example, okay, I cannot remember the class number.
No, so
I think
like
toys is
16
25, clothes is
paper,
16 is
18
stationery,
is
18 is apparel.
Yeah.
Right?
So every one you have
25
to
is
file.
bags.
Yes, correct.
It's
yes.
on a per class
Everything
charge.
that you want, you need to file. Each class is like few $100 or $1,000.
Okay, wait.
And then each country is also got
Sorry,
money.
sorry, I should have asked.
Yeah.
Okay.
It's very,
the,
very
the
expensive.
the saving grace
Yeah.
is that you don't strictly have to have a registered trademark in order to sue somebody else for copying your brand. Because there is a common law, this like claim called passing off, which is basically premise on misrepresentation. So as long as you can show that you have business in Singapore, you've done business in Singapore under this brand, in relation to these goods, this guy came along, he stole my whatever, and that's misrepresentation in terms of consumers being confused into thinking that he is me or that he's affiliated to me or is like in collaboration, then there is a chance that you can succeed on this claim. So you can do away with all the registration needs, but then just be aware that then the additional burden is to prove goodwill, which is the whole thing about business in Singapore. So you need to keep like your invoices, your receipt, advertisements, whatever, pictures of your merchandise in stock in the shops and things like that. So that will be proof that we will need to show to the court.
Yeah. The other thing is, I know what I learned when I was filing is that, let's say you have this grand plan. Let's say some of you all, maybe you all have very deep pockets, okay? Then you're like, okay, I want to be big in 10 years. I want to start filing and chopping everything right now. Also cannot, because you need to prove that it's being used. Yeah,
You don't have to prove use at the point of registration,
Yeah.
but you can be cancelled for non-use if you
Yes.
don't use within 5 years.
correct. So like you cannot just like you cannot just squat on it like buying.com. You cannot like squat on it like a domain. So I think a lot of things to learn. Then the other thing is, if you don't have a established company yet, but I would really recommend getting it formalized into a private limited, because then that opens you up to government grants. So I did take a MRA grant for the first round of registration for international trademarks. That being said, it was also another shocking experience because, okay, can I go to nitty-gritty?
Yes, please.
Okay, basically,
People listen 60 minutes for nitty-gritty.
okay,
Yes.
sorry. Okay, so basically, right, like the trademark registration period for overseas countries, like for example, US, because I'm chasing in US, then by the time the courts in the US get back to you, it's like a few months or 1 year later. Or maybe by now, I think it's been more. I need to check my email thread. Every time I get email from a lawyer, I'm like, I can't even remember what happened because it's like 1 or 2 years ago already. So I need to go and check. And it takes a long time for the whole thing to go through, especially if the name of your brand is not a name that you have come, like there's not a word that if it's a word that exists that does not exist yet, very good. Very happy for y'all. I go and name my brand Toasty. Toasty is a very generic word. It's very hard. I got a lot of things to fight. So, so basically we have to pursue things like cancel people's marks who are not being used. We have to, go down a lot of things. And then because that whole
She
process,
vibing with you.
because that whole process takes so long. Okay, when you apply for grants, right, you can only get your money back as a reimbursement upon completion of the project. So technically my trademark registration is not complete, but the first phase is complete. So I had to go and find and say, okay, I finished the first phase already. Let me claim back the first phase. After that, I don't think they will support me to continue pursuing based on the intermediate responses that we got from the patent courts. Then the rest, you are on your own for the cost already. So that's why I said it was shocking, because I started, then I didn't realize I will not be supported all the way. So it was kind of scary.
So if you had come to me,
Contrast. I say your invoice. Okay,
Maybe
can
you
you
save more money than the
the
money.
thing is that what we advise clients, right? So we have clients who are multinational companies and they say, oh, we want to come up with this new brand which we are going to launch in like 20 or 30 countries, right? Then we'll say, you go and do a trademark search first, right? Especially if the brand that they are choosing, like Chanel said, is something that is not not an invented word, but something in the English language. So then you face more problems that way. Even if it's an invented word, there have been cases whereby, oh, it's clear in Singapore, but in some country, there might be somebody who has already rights to a similar name, right? So you end up in a situation where, oh, I actually want to use the same brand name in 20 countries or even 10 countries, and suddenly you can't use in one country. What do? Do I rebrand everywhere, or do I just drop that country and have a different brand in that country, which is also very sian because you have a website and you just want one brand. Yeah, so I think if possible, go and do your trademark searches clearance first before you decide on what brand name to use.
Okay, fair. Awesome. That was a great discussion. So beyond trademark IP and all that, like some business advice in scaling the business?
So I think the other area of protection that I have decided on for ourselves is just to be as popular as we can be, because then you get like credibility on social media, because that's the only way you can fight against the big, like, deep-pocketed MNCs. And at the end of the day, like, if you have enough audience and let's say somebody takes your stuff and runs with it, the people who have been supporting you from day one, they know that this was your story and your concept first. And then as long as you can like prove that, I think you can be sufficiently protected within your community, because at the end of the day, we are all going to be copied. Like last time, this was already happening. Then now there's AI, so it's inevitable. You will be copied at some point. And the bigger you get, the more you'll be copied. Like even like Pop Mart, Sanrio, Disney, all their stuff is being sold by small businesses at every single art market that we go to. Okay, like we all know, we all see it. Nobody go and catch all the small business because it's not worth their time, right?
Yes.
But everything's being copied, and then they're just not big enough for them to like throw a letter at the small businesses that are copying them. So even big businesses are being diluted. You don't talk about luxury, don't talk about creator. I mean, fake or but same thing. Everyone gets copied. So how do you spend your time wisely? Just live with the fact. Pick your battles, exactly. Like there's no point to chase everything up to a certain point. And then I think some of my learnings were actually from like other US brands that I followed since I was like 10 years ago. Then they've like gotten bigger and bigger. Then somebody copied her skirt. I don't know if I can mention her brand name, but yeah, then she just went on social media and like she got all the skirts pulled, all the duplicate skirts pulled from all the big department stores in the US.
I think I know which one.
Yeah. And then after that, she even went and made all the
Scott,
skirts.
right? The one
The purple one. And then after that, she made some new pieces from the recycled fabric because all the dupes were pulled, right? Then she was like, oh no, but it's going to be wasted. So she actually took over all the duplicates and then she turned them into new products. And I was like, wow, it's a fantastic marketing campaign, like to turn a unsavory situation into something better. So yeah, I mean, we're all creative people. Can all be creative with the way that you stand up for yourself. Yes. Let's put it this way.
Okay.
Yeah.
So, since you let the cat out of the bag with the AI thing, also like I know just now Pimpin was saying like, oh, this is so AI, aspect of this whole game, right? Maybe we can move there.
So AI, I think the one thing that creators have to know about AI is that whatever you use AI to create, there's a possibility that it may not be protectable by copyright. Right. So how many of you know that? Yeah. So I think the objection is that when we talk about copyright protection, traditionally it's the human who does the creation. So there is this requirement for human authorship in order for there to be protection. In some countries, so for example in the US, they have rejected like applications for copyright registration on the basis that it was AI created. There's not enough of a human creative input, because no matter that you put in like hundreds and thousands of iterative prompts, it's equivalent to giving directions to a third-party designer. I want like that. Then the AI comes up with whatever output, right? Yeah, so I mean, that's the thing. I mean, but I think it's unavoidable that everybody's using some AI these days. Well, I would say that in terms of evidence that you want to keep, right, it would be just make sure that you keep the audit trail of like what prompts you put in. Then this is the output that came out at that stage. Then I put in this other prompt. So this whole process that you go through. Then this is the final output from the AI, and then I did these manual adjustments so that if you ever have to prove whatever parts of the creative inputs are yours, then you have this to show.
Even AI, all the copyright issues are still being discussed even now, I think. So they really haven't really decided like AI, when you create something by AI, what is the copyright subsistence going to
So
be?
it's like it's not a bright line test lah. So the court will have to look at in any particular case how much of the how much of the creative decisions were made by human as opposed to machine.
Yeah, because I think this whole thing about AI, it's still, we ourselves haven't really understood the whole
no
the
worries.
whole
I mean, it's an
world.
ongoing
Because some people
discussion.
tell me that it's a tool, but to me, it's no longer a tool alone. Like for instance, you use the DaVinci Resolve, you use Adobe Illustrator. All these are tools because you put things in, you design it and things. But AI, like you said, generates its own ideas as well. So to me, AI is more of a collaborator in that sense, but it's a machine. It's a technology.
So I think like one thing to note that relates to the contract angle is that more and more we're seeing that when brands, right, they hire. So sometimes we may be on the other side where the brand contacts you to say, can you draw something for me or create my marketing, something to use in my marketing campaign? Then if in the contract it says that there are warranties that say that I warrant that I'm the author of this work and that it's copyrighted. And so just be aware that if you're going to use AI heavily, then you might want to qualify that because you can't you may not be able to provide that warranty anymore.
So let's say for us, right? Do you use AI?
Yeah.
Yeah, in some of your storytelling, right? Like for us, we also use some of the AI elements in our storytelling, right? So in that process, how do I still substantiate that it's my work?
So I guess it depends on what you use AI for. If it's like let's say image generation tools, if you're using it to change the color or to create the background, so basically what we call assistive purposes, then that might be okay because like the substantive part of it is still whatever you came up with. If you use AI to edit this podcast, to make me sound
Don't call me
better.
out. But yes, we do.
Yeah. So if so it depends what you use AI for, and that will influence the ultimate finding as to whether the whole thing is protected.
I have a question. Okay, so I've been investing the last few months in training our own AI so that we can be faster with generating animated content. If you see the Tasty Toastys channel, I'm happy to be open about it because it is very expensive to grow an IP brand. Okay, if I want to compete against Disney, there's no way, right? One person. So 2D, we tried, cannot. The toast keeps hallucinating. It's very bad. It's currently we gave up. We gave up.
I've
on
seen
2D.
some of the iteration. It's quite
Oh
funny.
yeah. It's like blending into. It's very bad. Okay, so 2D is still handmade. But the 3D one, right, because there's more angles, it's more dynamic. So far, we are seeing very positive results. In fact, I would say in the past 8 weeks, some of the 3D content that we started to post,
It's gotten quite
majority is AI supported, right? But all the original work that went into training that AI is from us. It was created by us. So I know maybe you all don't know the answer because it's so new.
The original work, if it's created by you, that the copyright in that is not compromised, right?
Okay.
Just because you feed in an
So
AI,
it's clear.
suddenly no
So the
protection.
data set is
But what
from-
I'm
Yes,
saying
the
is
data set is ours and we spent a long time making that data
it
set.
doesn't influence the copyright protection for the
Okay.
data set. But what I'm saying is if the video that the AI eventually spits out, right? Because you're saying so if somebody tomorrow I go and copy your video, I go and post on or I use whatever, then you sue me for copying your video, then I'll say, but this video was created by AI, so there is no protection for the video per se. But if you're saying that, but this video contains my characters and that's my trademarked characters, I have goodwill in that, then you can still sue me, other causes of action, trademark infringement, passing off. If there is if in the video, let's say there's a frame that shows a certain image or picture that you drew, then that is still copyright infringement. So the question is, what is the AI output? So it's a bit legal and complicated.
Right. We still edit the AI output, by the way, because it's not perfect.
It's never perfect.
So we still need
At
to
least
edit
as
a
of
lot
now.
of things. But because 3D animation normally takes a very long time, now we can cut the number of man days per video, right? To feed the algorithm. So
I'd say don't be afraid of AI. I think the conversation where people were having in 2022 to say that, I'm scared of whatever, I'm not going to use it. That's 2022 already. Nowadays, nobody is saying that we're not going to use it. I think the question is, how do we use it with our eyes open, knowing what the issues may be and how to use it safely.
Awesome. I thought that was a great discussion. right? So, in closing, do you have anything else you want to share? Anybody, around IP, around protection? I think we've gone through quite a bit. If that's all, anybody last things to add? Okay, so if our audience enjoyed today's episode, where can they connect? How can they, get in touch with all of you?
You can DM me at Tasty Toastys. If it's a burning question and I never reply,
She will send you
then-
the burnt toast.
No. You can find
It's a
me.
burning
You
question.
can find my personal IG. It's Chanel Coco. But if I don't reply, means you just sent me hi. Then there's no context, so I will not reply.
Okay,
Yeah.
okay, fair. Ping Ping?
So I think you can find my profile on the internet. So my firm is called Bird and Bird. That's why I'm wearing a bird brooch today, so you can remember. It's literally Bird and Bird. And my name is O Pin Ping.
All right. My name is Laura Key. So, if you want to find me personally on Instagram and all, I'm Laura Key LT. But for VICPA, you can find us on Instagram on VICPA SG, or you can go to vicpa.org.sg. So I just want to, and also they're saying that VICPA is under NTUC. So you do get membership, you get all the perks from NTUC, the link points and the insurance and all those kind of things. But more than that, I think what's very important for VICPA is that we represent creative freelancers in work and business issues. And that's something that wasn't available before 2021 when VICPA was established. So I know we always say, oh, we're going to be fine, our business is going to be fine, everything. But the problem is when something happens, right? You never know when that something will happen. Then you need someone to turn to for support and all that. And I think that's where VICPA comes in. So we do have IP clinics, education, and all those things that we can offer, business support, work advisory. So you can check us out as well.
Awesome. Thank you. So for all of you at home, if you enjoyed today's episode, like, share, subscribe. I think they have a lot of plug. I'm not going to plug, but if you have further questions, put in the comment section. And I think it's a great event. I hope to continue to engage this space. I think there's so much more to develop and discuss. We hope to see you at the next TFC Business Show. Meanwhile, take care. Bye-bye.